In this lecture, which is divided in two parts, we will discuss the role of emotion in criminal law and criminal law decision making. For other aspects of the relationship between law and emotion, please also see other lectures in this module. Let us briefly stop at the definition of emotion. Researchers consider emotions from perspectives of various disciplines. Psychology, philosophy, sociology, and neurology may understand emotions differently. Moreover, there is diversity in approaching emotion even within one field. Thus, various strands of psychology, such as neuropsychology, evolutionary psychology, social psychology, and clinical psychology, each focus on different aspects of these phenomena. Discussions on emotions become even more complicated as different authors may use different terms when they talk about emotion. Sometimes terms such as feeling, sentiment, affect, or mood are used as synonyms, while other times they denote distinct but related concepts. However, despite the fact that there is no generally accepted definition of emotion within a particular discipline, let alone between different research areas, there is still a strong consensus on what causes emotions, what are their elements, and what are their effects. Emotions are usually elicited by an event or stimulus that is relevant to a person. Such event may be external, such as a sudden loud banging noise, or internal, such as a memory of a dear person. Thus, a necessary component of an emotion is usually swift appraisal process, evaluating an event or stimulus as important to the person. Such appraisal informs the individual of the nature of the event and prepares her organism for adaptive behavior. We call this the action tendency. The action tendency of a person who hears a sudden loud bang might be to quickly protect herself from the source of the bang. This coordinated response of the organism results in felt and often displayed physiological changes. For example, increased heart rate, modified facial expression, etc. And finally, in a subjective experience of a person feeling the emotion. Because of these features, emotions normally disturb our previous behavioral course and plans by creating new goals. Therefore, emotions can have a strong impact on our interaction with the social environment. One category of emotions is particularly relevant for law, and even more notably for criminal law. These are the so called moral emotions. While emotions in general are usually evoked by events and stimuli that directly affects oneself, the orientation of moral emotions is less self-centered and more pro-social. They are connected to the interests and well-being of either the society as a whole or at least other persons than those experiencing moral emotions. Moral emotions might condemn others, such as contempt, righteous anger, or disgust. They might be conscious of one's own behavior, like shame, embarrassment, or guilt. They may be sensitive to others' suffering, such as compassion, or may praise others for their moral qualities, like gratitude and elevation. The example of anger well illustrates the difference between moral and other emotions. If I get stolen my bicycle, I will get angry. However, if I see a stranger on the street stealing a toy from an innocent child, I might feel moral outrage, although the latter event does not pertain to me directly. This example nicely shows how moral emotions promote prosocial behavior in society. Moral emotions are interesting for our discussion because they are related to moral rules, which underpin many legal rules. Moral rules are also important factors in moral decision making and in legal reasoning. Before exploring the role of emotion in legal decision making, let us consider how emotion is incorporated in our everyday judgments. A useful starting point for this discussion is Kahneman's division of human cognition to System 1 and System 2. System 1 is quick, intuitive, effortless, and draws for emotions, while System 2 is slow, analytical, determined, and effortful. System 1 is much more prevalent and more efficient in our everyday decision making, and we need to make hundreds of decisions every day. However, System 1 is also more prone to mistakes. This is why The role of System 2 is to either reevaluate and correct particular judgment of System 1 or to independently resolve more complex cognitive tasks. For example, System 1 will deal with the decision what to order when going out for lunch, whereas System 2 will get involved when we try to navigate our way in a city we have never been to before. In this module, emotions first acts as a powerful indicator of System 1, facilitating its quick and efficient decisions. However, emotions also suggest a decision to System 2, which may, through more thorough deliberation, either confirm or reject it. It comes as no surprise that jurists are as susceptible to emotions in their decision making as any other human beings. However, acknowledging the presence of emotions in the process of legal decision making opens a plethora of other more complicated questions. They relate to the overarching theme of how do and how should emotions integrate into legal decision making. The first set of dilemmas pertain to the relation between emotion and the so-called rational reasoning. Can and should these two components be detached? Does emotion inevitably obscure rationality in legal reasoning? Are there some emotions or types of emotions that are more desirable than the others in this process, or is it in the intensity or another quality of experienced emotions that is more relevant? Perhaps the instigator of the emotions should be also taken into account. Emotions may be more or less preferable whether incited by the alleged crime, its outcome, the perpetrator, or other stakeholders involved in the criminal trial. Finally, there are many different decisions being taken in the context of a criminal trial. Emotions may not have equal relevance for all of them. For example, righteous anger may influence a sentencing decision, but not the decision on a criminal responsibility of the defendant. It appears that none of these questions can be resolved with a general answer. Fengensen and Park offer a useful model on how emotion might influence legal decision making. They propose three ways in which emotion impacts the process of legal judgment. First, emotions can influence individuals' strategies for processing information. Thus, for example, some emotions such as anger, disgust, and happiness typically pair with a sense of a higher certainty in a decision maker, which may in turn reduce our analytical processing of legal relevant information and increase susceptibility for heuristic based solution. Interestingly, this effect has been confirmed in a criminal law context with professional decision makers, namely the Swedish crime investigators, when assessing reliability of a witness. Angry as opposed to sad, investigators more readily employed heuristic processing of information. Second, emotions may produce mood congruency effect in legal decision makers. This means that people in positive moods tend to make more positive evaluations of ambiguous information. Conversely, people in negative moods tend to interpret the same information more negatively. Thus, evaluating inconclusive evidence, a prosecutor in a negative mood might perceive, interpret, or memorize more details unfavorably for the defendant compared to a prosecutor in a more cheerful mood. Finally, emotions may affect the way people make particular decisions by providing informal cues. These mechanisms operate in a variety of very distinctive and sometimes complex ways. In a criminal law context, the impact of emotions evoked by some features of the criminal case seem of particular relevance. One study, for example, showed that conviction rate in a group of mock jurors with greater anger induced by gruesome photographic evidence was significantly higher than in a group that was not shown any evidence. It is assumed that decision makers in such situations use their emotional state as an information cue concerning the judgment target, in our case, defendant's blameworthiness. Let us take the example of anger and briefly present some research looking into the effects of this emotion. Anger is usually experienced when a person deems that a responsible other has caused an event that one appraises as personally relevant, but incongruent with one's goals, particularly when such events are perceived as unjust or unfair. Psychologists, however, distinguish anger on the one hand from righteous anger or moral outrage on the other hand. The latter is more common with decisions makers in criminal justice. Moral outrage is typically caused not by perceived harm to the person experiencing this effect, but by harm caused to someone else or by a breach of some moral norms. Research indicates that anger in decision makers directly or indirectly increases their punitiveness towards the defendant. An interesting experiment investigated how anger impacts mock jurors' assessment of criminal intent in an embezzlement case. They found that angry jurors attributed more criminal intent to the defendant compared to neutral and sad ones. Consequently, this led to jurors' greater punitiveness. Another experiment measured how mock jurors' anger reflected in their sentencing decision in a capital case trial. It discovered that the angrier the jurors were, the more likely it was for them to decide for a death sentence, as angrier jurors estimated mitigating circumstances of the case presented by the defense as weaker. Another study using a murder case, where anger was imposed by a victim impact statement, also revealed that angry jurors were more likely to opt for death sentence compared to both neutral and sad jurors. However, can we generalize these findings to decisions in real criminal trials and to professional legal decision makers? Experiments investigating the impact of emotion on decisions of judges and other criminal justice professionals are extremely scarce. Therefore, we should be very careful in drawing any direct inference from studies on mock juries to judgments of professional legal decision makers. The first caution stems from the fact that legal decision making is governed by a complex set of substantive and procedural legal rules, legal principles, and rules of interpretation, which legal theory usually denotes as legal reasoning. Secondly, through education, training, and professional socialization, professional legal decision makers are typically much aware of these rules and hence of the fact that legal reasoning is not and or not to be done in the same way as other human judgments. We can hypothesize that such motivated cognition of jurists mitigates the effect of emotion in legal decision making to at least a certain degree. Methodologically, however, this hypothesis is difficult to test, not at the least because neither actual jury members nor professional jurists are readily accessible for this type of experiments. An equally important obstacle for research is that in the process of legal decision making, say in a criminal trial, many emotions might be experienced and many different decisions are taken. It is, therefore, difficult to isolate the impact of just one emotion and apply it to just one judicial decision. Notwithstanding, one such intriguing study with 53 Norwegian judges revealed that emotions displayed by the witness victim during her testimony did not influence judges' witness credibility assessment nor their decisions on defendant's guilt. Conversely, an identical scenario tested on law decision makers revealed that law people, in their assessment, relied heavily on victims' displayed emotion, rather than on the content of her testimony. Discordant with these findings are results of a study with the Swedish police investigators. It revealed that angry, as opposed to sad, professional criminal investigators evaluating witness credibility did not pay attention to the consistency of the witness statement with the main investigation hypothesis. This indicates that anger indeed influenced the investigators' information processing strategy and conscientiously their professional judgment. The few mentioned studies do not allow for any general conclusion of the impact of emotion on the decision making of the criminal justice professionals. However, they allow for the assumption that the significance of the experienced emotion on legal judgment does not only differ between law persons and legal professionals, but might also vary between different groups of professionals within the criminal justice system. Much discussion at the intersection of law and emotion revolves around the role of empathy and whether it is desirable in legal decision making. However, there is also considerable terminological and definitional confusion about the terms in literature. Most scholars, nonetheless, agree that empathy is not an emotion but rather a capacity to feel or understand other people's emotions, as well as their thoughts, perceptions, feelings, and other cognitive states. Here, a distinction should be drawn between affective and cognitive empathy, which is very important in the legal context as well. When experiencing affective empathy, one person is in a similar emotional state to another person's emotional state due to perceiving another person's situation. By cognitive empathy, on the other hand, we mean that one person is capable of understanding another person's state through cognitive processes. Thus, with cognitive empathy, we use cognitive perspective, taking to project ourselves into the circumstances of another person. When exploring the role of empathy in legal decision making, it is therefore useful to clarify which type of empathic capacity one has in mind. Perhaps, also due to this definitional vagueness, the debates on whether it is beneficial for judges to use empathy in their work entail arguments pro et contra. Some scholars emphasize that empathy is an essential human capacity, which, through understanding other people's affective and cognitive state, enables us to function in a social world. Hence, it is also an essential prerequisite in judging, as it enables judges to understand other people's conduct and gives them basis for their moral reasoning. In that sense, empathy is a valuable source of human knowledge and benefits a legal decision maker, both in the process of discovering a solution as well as in the process of justifying this conclusion. In a criminal law context, understanding defendant's perspective can give valuable information concerning both defendant's criminal responsibility and sentencing decisions. A study by Wettergren and Bergman Blix provides an interesting example how empathy is used as a valuable legal reasoning tool in prosecutorial decisions. This study reports of a prosecutor who was in a dilemma whether to press charges for the offense of aggravated unlawful threat and the suspect's conduct caught on CCTV cameras was somewhat ambiguous. By thoroughly analyzing the suspect's behavior, the prosecutor has finally concluded that the suspect panicked and reacted under fear rather than with the intent to threaten. Interestingly, in sustaining her decision not to prosecute, the prosecutor supported her conclusion by employing empathy. She explained that the emotions of fear and panic is what she would have felt in the suspect's position. On the other pole, some authors raise concerns over improperly using empathy in judging. These range from claims that empathic imagination has no normative significance in judging to fear that empathy may lead to partiality and bias and therefore might be inconsistent with objectivity and the rule of law. In that respect, Bandis warns against selective empathy. When a judge more easily empathizes with a party having a background familiar to the judge compared to a person with dissimilar life experience. The criminal justice system seems particularly sensitive setting for selective empathy, where defendants are often marked by disadvantaged socioeconomic, family, and educational backgrounds or come from otherwise marginalized social groups. In contrast, this is typically not the case with judges, prosecutors, and other legal professionals. Judges' empathy might thus be more readily accessible for some victims or perhaps defendants with more relatable personal profiles to the decision maker herself, for example, white collar crime defendants. A study conducted among Australian judicial officers reveals that a majority of them believe that empathy is essential or very important in their day to day work. We can conclude that empathy is an indispensable human capacity, allowing a legal decision maker to fully comprehend different perspectives of the stakeholders involved in a case, along with the legally relevant emotional aspects. On the other hand, its potential selective application, together with its ability to invoke emotions in the decision maker herself, may go contrary to the postulates of impartiality and objectivity. Therefore, legal professionals should be mindful of this ambiguous nature of empathy.